This panel is why adjudicate first. There is an implicit question in that, which is that there's an assumption that you should do so. We can discuss at the end whether that's actually right, but can I plant this thought right at the start? It does depend what you want, and sometimes there is an implicit assumption that what clients want is a quick, speedy resolution. My experience is that sometimes they want a long, drawn-out, bloody war. Now, why that should be may be a matter of, the risk allocation of the contract, hoping that something's going to turn up, hoping that people will get bored with supporting Ukraine, whatever it happens to be. But one should just question assumptions that what the parties really want is a decision. They may want the opposite of that. They may want a tactical win. They may want to have 42 different adjudications. Now, to discuss these interesting questions, we've got an extremely distinguished panel. It's like one of those pub jokes which are now banned on the grounds of cultural sensitivities and inadequate diversity. But we've got a quantity surveyor, an engineer and surveyor by background, a barrister, well, you've got to have two of one thing, and a solicitor. They are all in their field extremely well known. I think all of everyone here practices to an extent as an adjudicator as well as either an advisor or an advocate and also an arbitrator. We're going to start by dealing with the quantity surveying aspects by background. Dean's going to talk about cost. We're then going to move on with Patrick, Waterhouse, to time. And then Abdul is going to talk about what started off as being inevitability, but which I think means what the default positions are, what the choices are in various different places. And then finally, Richard is going to talk about the psychology of adjudication. And I'm really interested about that because solicitors talking about psychology really does strike me as being something which I've got to hear. So without any further ado, Dean, do you want to start us off? Do you want to have the... Oh, there's probably one up there.
Okay, good morning everyone. So I'm going to talk about the cost perspective of adjudication and bear in mind that I've been tasked with putting forward the case for adjudicating first, with my main focus being on costs. Therefore, what I've got to say really just represents one point of view, and there could be arguments against that point of view. So 2 points really is that adjudication achieves better cost control and cost certainty, one argument. And another argument is that adjudication achieves reduced costs. So looking at the first argument, that adjudication achieves better cost control and cost certainty. So if we go back to the Housing Grants Construction Regeneration Act 1996, which was enacted in 1998, it contained no provisions for pertaining to party costs in adjudication. As a consequence of that, as adjudication developed, so-called tollant clauses became popular, with which undoubtedly many of you will be familiar with. But tollant clauses are those included in a contract which allocate the party's adjudication costs to the referring party. And they arose from the Bridgeway and Tollant case. As a consequence of that, it became fair game to use a sledgehammer to crack a nut if you were the responding party, knowing that the referring party would pick up the bill. So adjudication could have been expensive for a referring party, bearing in mind that it's had its own costs to pick up as well as those of the responding party. We move forward to 2011, when the Local Democracy, Economic Development and Construction Act 2009 was enacted. In that act, Section 108A was introduced to make it unlawful for a contract to allocate parties' adjudication costs. In essence, that meant that the parties in adjudication would bear their own costs in those proceedings. Now, Section 108A does allow the parties to agree after the service of the notice of adjudication that the adjudicator can decide and allocate costs. But in practice, in my experience anyway, actually in over 150 adjudications, not once has that been agreed. Therefore, invariably the parties' costs in adjudication lie where they fall. That means that the parties can now adjudicate with the benefit of having to concern themselves only with their own costs. They therefore have far more cost control and certainty over their costs in the proceedings than they would do had they decided to not to adjudicate and to go headlong into an arbitration or a litigation. So, in summary, adjudication proceedings, if you adjudicate first, you have far more control over the costs that you will incur and more certainty as to what they will be. So moving on to the other, the second point is that adjudication achieves reduced costs. So there are a number of points in relation to this, and they are arguable, but bearing in mind that I've been tasked with putting forward the case for adjudicating first, I shall look at the positive aspect of that. So arguably, there is far less of a requirement for experts and expert reports in adjudication proceedings because the adjudicator is likely to be an expert or at least very knowledgeable in the subject matter of the dispute themselves. Now, when you apply to a adjudicated nominating body, you set out the brief details of the dispute and what you are looking for from that adjudicator or an adjudicator that they are to nominate. Therefore, you should, in theory at least anyway, perhaps not always in practice, be appointed, or an adjudicator should be appointed who has an in-depth knowledge of the subject matter of the dispute. As a consequence of that, experts are less likely to be needed, although in practice there are parties do obtain expert reports for submission in the proceedings, but arguably that is not strictly necessary, and a good advocate could run the case without an expert report and thereby reduce the costs to the party that they're representing. The parties can actually run adjudication proceedings themselves if they've got the necessary know-how or expertise in-house. This can avoid having to employ expensive advocates, lawyers, quantity surveyors, whoever they may be, and they can get on and do it themselves. In practice, again, that probably only happens, in my experience, in smaller disputes, but the opportunity is there, and therefore that will reduce costs in comparison to those for other proceedings such as arbitration or litigation, where invariably you have lawyers, etc., and experts, etc. Adjudication is a swift process with a decision within 28 days of the referral, which avoids incurring significant costs over a prolonged period of time. As everybody in here will obviously be aware, that litigation, arbitration proceedings can take many months to reach a resolution with many hearings, etc. Adjudication is swift. It's legislated to be done within 28 days. It doesn't always happen, but invariably the idea is to still get a decision within a reasonable period of time if the parties agree that the adjudicator needs some more time, or they need some more time and the adjudicator agrees that they can have it. But it's far quicker than any other process and thereby reduces the costs of the process. Another point is that it's reported that 90% of adjudications they proceed on a documents-only basis. Therefore, this avoids the need for expensive hearings. Indeed, I've represented parties in excess of 150 adjudications, been to 2 hearings, and the hearing that I did attend ended up with 2-3 lawyers from each side. The referring party appointed a barrister, so we had to appoint a barrister. Then they had a solicitor, so we got a solicitor, and it was a 4-hour hearing that didn't really get anywhere, very expensive, completely unnecessary. So that is largely avoided in adjudication. It is invariably done 9 out of 10 times as a documents-only procedure. Another point to make is that adjudicators' fees are generally pretty reasonable, certainly in my experience, and therefore it shouldn't be overly concerning if you were to lose and you are awarded the adjudicator's costs. In my experience, again, in over 150 adjudications, I have probably had 2 occasions where I've received a bill from the adjudicator where I thought, wow, you know, how on earth have you got to that number of hours and that fee? But majority of the time, complex disputes, the hours that are clocked up, in my experience, have been reasonable, with reasonable rates, and far more reasonable than you would see had you not adjudicated and decided to arbitrate or litigate. In any event, there are now various schemes, such as the CIC LVD MAP and the capped fee scheme offered by UK Adjudicators, which fix or cap an adjudicator's fees in the relevant proceedings. So there is another aspect to adjudication which has been developed over the last few years with a view to making adjudication more accessible to everybody, and particularly on small and medium-sized entities. You can fix or cap adjudicators' fees in particular circumstances. Furthermore, adjudication can be used to obtain decisions in relation to discrete parts of a dispute, thereby avoiding the need to have to refer such parts to costly arbitration or litigation proceedings. So if you have a large dispute, but one aspect of it turns on a particular point, you can refer that point to adjudication, have a temporarily binding decision, and it may be then that the other party agrees with whatever is decided in that adjudication, and it means that there is less then to refer to further procedures that have finally determined. Furthermore, if an adjudicator's decision as to discrete parts of a dispute aids further negotiation between the parties, then it may result in having to avoid to refer the overall dispute for final resolution in more costly proceedings. Or at all, the parties may settle, and that's the end of the matter. So, although adjudicators' decisions are generally binding on an interim basis only, it is widely reported that in a large proportion of cases, an adjudicator's decision is accepted by the parties and not subsequently challenged by them in a final determination in arbitration or litigation, thereby avoiding the need for more costly arbitration or litigation proceedings. And a final point on adjudication achieving reduced costs: parties can also agree the identity of their adjudicator, thereby perhaps picking somebody by agreement who they know will only you spend a reasonable amount of time on the dispute. It's not going to be excessive. They operate or act at reasonable rates, and therefore it will be a reasonable amount at the end of the day for whichever party has to pick up the tab. And that really, in a nutshell, is the case for adjudicating first from a cost perspective.
Thank you very much. What struck me a little bit about what Dean was saying there is that of all the functions which we can fulfill here, experts, adjudicators, arbitrators, and so forth, he wasn't even pretending to be independent, so he's plainly acting as counsel in this particular respect. What one would be interested to know is what his expert opinion would be in relation to the questions he put forward, still more what his adjudication decision would be, but no doubt we can ask him about that in due course. Patrick, you're going to tell us about time.
Yes. So one of the alleged advantages of adjudication is time. The question we were given is quite provocative. Why adjudicate first? And the addition of the word first tells part of the story that there is a perception that it might be something you do as the start of a longer process, whereas I think a number of speakers have said this morning already that the vast majority of decisions are either accepted by the parties or the courts are usually keen to enforce outside of a number of situations like natural justice and jurisdiction. So we're told it's a 28-day process, and in my experience, it's not very often. I'm not a party advisor. I either adjudicate disputes or I teach people how to use contracts properly. So if they don't follow the first bit of my advice, they tend to meet someone like me shortly afterwards. And the adjudications I get involved with, where they're 28 days, they tend to be those falling under the lower value disputes that CIC, TEXA have. The vast majority, I think, fall in 42, possibly to 56 days range. That still, though, when I spoke to a number of lawyers in the last week, because I'm not involved in arbitration or litigation, even 56 days is vastly quicker than what I'm told you would get with another form of dispute resolution. One of the solicitors I spoke to said, don't look at purely the time of the adjudication. When does that party get its money? And he said, even with adjudication, they're still likely to get their money much earlier than other forms of dispute resolution. And I must reinforce, I'm only speaking in terms of the UK today. I've no experience of adjudication overseas. So the courts, we know, will enforce time limits. We're allowed to get things wrong as adjudicators, but broadly speaking, we're not allowed to be late. And sometimes the process is described as rough justice, that you pay now and argue later. And as we've heard today, the arguments probably don't work much later on. And the decisions of courts enforcing decisions, I think, has led to a situation where parties take the adjudication very seriously. We're told, for those of us who can remember, and I must say, although I was working in the industry in the early 90s, I wasn't in dispute resolution, but we're told when it first came in, and I'm predating 96, by the way, because those of you working with NEC contracts in the early 90s will have come across it. We were told it was going to be an informal process, and people complain it's turned into a legal one. Well, if this is your only opportunity to actually secure your payment or to defend a scurrilous claim, then of course you've got to take it seriously. And when I spoke to an arbitrator friend last week, he told me he's got one on at the moment. It's really quite a quick one. He said we might get to a hearing in about 6 to 8 months. And for those of you who work in adjudication, you'd giggle at that, but he assured me that was one of his quicker ones. And I think the benefits we seem to have as adjudicators are instructing and directing our parties what to do and when to do it. And you've heard from a couple of people this morning about the challenges of coordinating diaries of people who are busy. And that's certainly a challenge, but in adjudication, I always try and get the parties' agreements to extended timetables. But in the event you can't, you have to direct. You have to say, I want that submission by that date. And largely speaking, you get it. We have some parties abusing that position. I've had a couple of Christmas ambushes in my time, one of which I genuinely felt for the responding party. It was a private client, and she was served the notice of adjudication on the 23rd of December at 2 o'clock in the afternoon while she was hosting a family lunch, in a situation where, put bluntly, she had not, as we found out several weeks later, she had little to answer for. There is a tactical advantage that the referring party has to timetable, and that, I'm afraid, is part of the challenge. Where people are busy, and typically the good people in life are busy, there are things parties can do, and we have at least one case on file at the TCC where the referring party just pulled out because their counsel was unavailable to take it any further at that point. Adjudicators have to learn to count 28. Despite what I said about not many cases concluding in 28 days, some do. Some do because, particularly further down the food chain in the industry, people genuinely need their money. And they will not extend it beyond 28 days because they are stretched for cash. They've possibly told their shareholders, their banks, that I've got a good chance of X pounds coming in to this timescale. You ask for more time and they'll just say, no, we must have a decision on a certain date. If you look at Coulson, and always a good thing to do is to quote someone cleverer than you when you want to avoid criticism, he quotes 5 problems with timing. Firstly, and I think someone mentioned this earlier, complex and large disputes. If you're going to spend 5 or 6 months on a high-value, complex dispute worth tens of millions, would you be better litigating anyway? Because the time advantage is starting to evaporate there. The parties need certainty. Coulson describes that as paramount, and I think timing, as well as costs that you've just heard from Dean, I think timing and costs are the 2 big advantages. Parties must reply to requests for more time. Now, there's a number of cases we've seen where adjudicators have run out of time because they've asked for more time and one of the parties hasn't responded. There was one case, I think it's about 5 years ago, with Dennis Baldwin, I think wrote to the parties and said, I need however many more weeks it is, and I assume that you agree unless I hear to the contrary. And unfortunately, he wasn't successful with that. The 28 days, if it is 28, is not a guideline, according to Coulson, it is absolute. And where we have final account disputes, of course, it becomes all the more important you get it done on time. In terms of the ability to count to 28, one situation I came across because of a complaint received by a nominating body was an adjudicator who had missed that the public holidays in the various jurisdictions of the UK differ slightly, and that doing an adjudication in a different jurisdiction to where he lived and worked, he'd missed that there wasn't actually a bank holiday he had allowed for. And so he eventually gave his decision on day 29. It didn't reach the courts, but both parties said they weren't going to take it any further as a result of that. The longer timetables of litigation and arbitration sometimes are justified by the parties doing it because they want what they perceive to be a better result. You've heard from several referring party representatives today what they think of certain fine adjudicators in the industry, and as an adjudicator, I'm afraid I have to agree, and there may be some of you out there thinking he's been a bit hypocritical here, but as Roger said, we can't see who's here at the moment, but I deal with complaints about adjudicators at two leading professional bodies, and occasionally we get things put in front of us that are absolutely terrible. So those concerns you might have about the adjudicator may only be in a minority. I hope they are in a minority, but they are real. And the concerns about arbitrators that somebody mentioned earlier, although I've no experience myself, I also picked that up in talking to people last week in preparations for today. The case law separates two timings for adjudicators. There's reaching your decision and communicating it. This panel managed to arrange the order in which we spoke between about 20 to 10 and 10 to 10 this morning during the previous speakers, because it was one thing we hadn't managed to arrange in our meeting last week. Modern communications, I think, means there is no excuse for reaching your decision on day 28 and somehow communicating it on day 29 or 30. So I've not received any paper from parties to an adjudication since the start of COVID. I've not asked for any, to be honest. I think all of our communications are electronic. So even though there were some early cases in the TCC about communicating a decision that was reached on time but not sent on time, I don't really think there's much excuse for you communicating it late to the parties. So overall, I think time is the big advantage of adjudication, the ability of the adjudicator to direct the parties in what they do. The time limit was set by Parliament, so you often see people justifying their strict timekeeping because this was Parliament's intention. And of course that does impact upon the way the rest of the decision is reached and the other aspects of the adjudication. Thank you.
Thank you very much, Patrick. One of the things which struck me from listening to what you were saying was it is sometimes difficult to remember just what an enormous change the institution of compulsory adjudication in this country was. It was probably the biggest single interference with freedom of contract in this field for a very long period of time. And if one thinks of the occasions when there's a justification for interfering with freedom of contract, mucking around with the construction industry wouldn't strike you as being one of those. And it is, I think, really quite interesting that there is, as far as I'm aware, no call to get rid of adjudication. And I think that's probably in large part because of what you were saying about the very large number of decisions which are not taken further. And although I'm certainly aware of an enormous number of complaints about adjudications, adjudicators, processes, and it may well be that I see by definition the ones that go wrong, it really is worth remembering that there isn't, despite all of that, I think, anything approaching a call for some kind of, let's just go back to letting people contract as they want to. And with that, we come to Abdul, who's going to talk to us about the default position and where we get to on this.
Thank you, Roger. If I may, with your permission, follow the tradition in the TCC of making my submissions from a sitting position rather than standing. Thank you. Somebody whose name I always forget said there are 3 things in life that are certain: death, trouble, and taxes. If you work in UK construction, I'd add adjudication as the 4th inevitability in your life. Adjudication has become increasingly a feature of construction in the UK. So looking at it from the perspective that Roger and I sit at, which is we see things when they go wrong, it is incredible to see the extent to which adjudication has grown since its formal introduction statutorily in 1998, and the extent to which it's crowded out UK domestic construction arbitration, and the impact also had on UK domestic litigation. Now, I think one has to start from the position of looking at things from domestic perspective and internationally. Domestically, of course, we've got the Construction Act, which gives people the right, not the obligation, to adjudicate. And it's interesting to see how adjudication has grown in that context, because I think I was around at the beginning of adjudication, and I can recall that there was some doubt in some quarters about the extent and degree to which industry would make use of this newfound right. And I mean, all of us in this room, I think by definition, we're sort of self-selecting group in that all of us practice in adjudication, so we all know how popular adjudication has become. It has become almost an inevitability in contracts. And there's a good reason for that. And one can see that when you contrast it with the international position. Say for a handful of jurisdictions, in Australia, for instance, where there is statutory adjudication, adjudication is a creature of contract, generally outside the United Kingdom, with a few exceptions. It is a creature of contract. There have been various attempts in lots of jurisdictions to introduce it. I practice a lot in Africa. I know that in South Africa there was an attempt to introduce statutory adjudication, didn't go anywhere. So the UK and a few other countries are sui generis in the sense that they've got adjudication as a statutory provision. In the jurisdictions where you don't have adjudication, you will see the problems that arise from a lack of what I describe as a force multiplier on the part of subbies and main contractors. And I call it a force multiplier because adjudication gives parties a route that is generally quick and generally cheaper than the alternatives, which internationally generally is arbitration, to try and resolve disputes, particularly in reference to one issue, and that's cash flow. The underlying rationale for a lot of the Construction Act came from the Latham Act, also Latham report, where the report commissioned by the government in the late 80s, early 90s, that identified the major problem in UK construction was cash flow. And the UK serves as a useful contrast, as I say, to other jurisdictions where you do not have adjudication as a statutory right. It's a creature of contract. I hope there are no easily offended vegetarians in this room. I'm going to tell a story that I was told by an instructing solicitor earlier this year who works in a certain jurisdiction in the Middle East. Before going into private practice, he worked as an in-house solicitor for one of the big four developers in this unnamed jurisdiction. And he told me the story about their approach to contractors. Now, this is a very large developer. And he said that the analogy he was told on day one was that you have to look at the contractor as the rabbit. and money is the lettuce. What you do with the contractor is that you give him enough lettuce, so enough cash flow, to keep him alive and stop him going back into his hole. You give him some lettuce at the outset, so he starts to work, and as the works project, you give him a little bit more just to keep him going, to stop him going back into his hole. You get to approximately 80% completion, and you take out a big stick and whack it over the head. That big stick being you call in the bonds. And you stop giving him any more money, you call in his bonds, he's in distress, you then go and negotiate with his subbies directly to get the works completed, and by doing that, you cut out his margins, you get the works done cheaper, and if he ends up fighting you, then fine. It's unlikely he will be able to because he has no money. But if he does, you're looking 2-3 years down the line for a resolution if you go into arbitration, and in that period of time, you had use of his money and had use of the project. That story illustrates one of the major benefits of adjudication to the UK construction industry. It has acted as a means of protecting the cash flow of contractors and subcontractors. Now, prior to the Act in '96 and it coming into force in '98, there are those in this room who practice in those times. And while things may not have been as extreme as in the jurisdiction I'm just describing, it was well known that employers, main contractors, use cash flow as a means of controlling their subcontractors and contractors. And if they felt like it, they just turn the tap off and stop giving them money. And that put the contractor or subcontractor, and frankly speaking, it was mainly subcontractor, main contractor, subcontractor relationships, it will put the subcontractor in a great deal of difficulty. So when I describe adjudication as a force multiplier, which is sort of a quasi-military term, what adjudication has done is that it's given the subbies and those down the contractual chain a different mechanism, a more effective mechanism for achieving a fast, quick resolution of matters which for them can be matters of life and death. I think we mentioned earlier on that there may even be a reluctance to extend the period of adjudication because a subby has given assurances to its bank that X amount of money is coming into my account by so date, and that's how crucial that the issue of cash flow is in the industry. So that has driven what I see as the inevitability of adjudication in the UK industry. The other facet which I want to touch on is the extent to which adjudication has fast become sort of the only mechanism people really use to resolve these disputes. The vast majority of disputes that I've been engaged in, as either as adjudicator or as counsel acting in adjudication, don't go beyond the decision stage. You want to get a decision, people by and large tend to live with it. Even in very large disputes, it's only if there's a particular tactical, strategic reason for pursuing the issue does it then go on to the parties wanting to commence proceedings to try and overturn the decision. So adjudication acts very much as the one-stop shop for, I would say, the vast majority of disputes now in the construction industry, which has all sorts of effects, some beneficial, some not for us lawyers, but that's reality. There is a growing practice now, which is a sort of an adjunct to all of that, which is the use of the Part 8 procedure to try and short-circuit proceedings in adjudication. While you don't get people seeking to relitigate the entire dispute by way of a straightforward Part 7 claim, increasingly I'm seeing parties attempting to use the Part 8 procedure. For those who aren't aware of what the Part 8 procedure is, Part 8 is the provision of the CPR that allows you to have an expedited hearing of a discrete issue that really is devoid of facts. It's really things that are to do with essentially the construction of a document, issues of law. And I find increasingly in my practice that people are trying to use the Part 8 procedure as a means of getting a resolution, sometimes during the adjudication. So ongoing adjudication, parties will try and get the Part 8 in to try and resolve the issue or part of the issue the adjudicator is looking at in the courts. Or once they've had a decision, there'll be a discrete issue of law in the decision which they feel agreed by, which they'll then try and resolve by the Part 8 procedure. Part 8, let's say, is supposed to be quick, it's supposed to resolve things. It's much quicker than Part 7. And people are turning to it more and more, in my experience, in an attempt to try and get the courts to intervene. Now, Part 8 is, in of itself, it's hemmed in by lots of quite tight, rigid requirements, and the number of times I've had people come to me trying to get a Part 8, and I have to say to them, unfortunately, I don't think your dispute falls within the parameters, and it won't work. So, yeah, I think just to conclude, I think the position that we find ourselves in, certainly in the UK, is adjudication is here to stay. Adjudication is popular. Adjudication serves, in my view, a vital function in the industry. Internationally, it's a different picture. By and large, it's a creature of contract. Parties will use DABs if the contract provides for it. The FIDIC generally requires to have a standing DAB body. Parties will, because they don't want the cost, will very often not appoint a standing DAB, which can then lead to other problems down the line, which I could sit here and talk for another 40 minutes about, but I won't. Yeah, to answer the question directly, I think, as I said, adjudication, inevitable, and that's a good thing.
Abdul, there's a whole lot there, which if one had time on, would like to pick up on. I did quite like what you were saying about the terminations in the Middle East. I have to say, I don't think there is another part of the world where I get retained more often, where the project is almost complete and there's a termination. It is quite well known. It is also astonishing how people are surprised when their bonds get pulled, and I do sometimes feel like saying, which part of on-demand bonds did you not understand when you agreed to provide on-demand bonds? And finally, when I look back at the contractors that I acted for in the late 1980s, they aren't there anymore. It does really remind me, risks were taken which were never priced for. And, it's like the old joke, how do you make a small fortune in construction? You start off with a large one. A large part of construction problems are because the contract's been underpriced or the risk has been underpriced. And often you've got an overall loss-making project where you're not talking about dividing up profits. You're deciding which proportion of losses should be attributed because the thing for one reason or another was a bad idea. Anyway, that's another whole topic of its own. But what we're now going to hear is the part of this which I really want to hear, which is Richard on psychology. So go for it.
Thank you, Roger, and thank you, Abdul. I mean, I have to say personally, I did like the story of the lettuce. Very topical, of course, and I think possibly quite a large proportion of the room here would also like to have had a big stick. Anyway, that's another story. Yeah, so the psychology of adjudicating first. I'm a big fan of adjudication. I'll disclose that straight away. I think it's an excellent process and there's a lot to commend it to parties, but you need to be careful with the process and you need to manage it. I'm interested in a sort of show of hands in the room. Who, based upon what you've heard so far, thinks that you should adjudicate first? You put your hands up. Okay, so it's probably about 80%, 90% of the room. Okay, how about this question? If you're the responding party and you've been served with the notice of adjudication at 4:30 on a Friday afternoon before a bank holiday weekend, in that situation, do you think you should adjudicate first? Show of hands. Okay, about a few more hands, about 15 hands in the room. Okay, Yeah, I don't like ambush adjudications. I think they should be avoided, personally. First of all, what do we mean by the question? Do we mean, do we adjudicate first, as in, were the parties starting the adjudication? In that case, I think there's a lot to say that you do want to be the party to first adjudicate. And we know that the statistics and the data collected by the Construction Dispute Resolution, Janie Milligan, in conjunction with the Adjudication Society, support the fact that the referring party often is the more successful party in an adjudication process. I think personally that is clearly more to do with the fact the referring party gets to choose the landscape of the dispute. They get to take as long as they want to prepare their case and their evidence to support and substantiate their case. But if we mean, would we rather adjudicate first as opposed to going directly to a final form of dispute resolution, such as arbitration or court litigation, then I still think on balance, adjudication is preferable. As I said, as the referring party, you get to pick the dispute. So you get to pick where you want to go with that dispute. You don't have to have a kitchen sink final account dispute. You can go for the low-hanging fruit on the accounts. So I've got one adjudication in process at the moment where we've targeted an obviously wrong approach by the project manager on an assessment of an interim application where a large deduction has been made, and we've just slung that straight into an adjudication, excuse me. And I'd hope that that would be a 28-day adjudication. We don't need expert evidence. We don't need witness statements. It's a question of yes or no, the deduction could be made. On the other hand, I've also this year had some very complex disputes in adjudication. So to give an example, we had a professional negligence claim against a firm of international consulting engineers. It's very complex, and we referred that to adjudication. Now, the professional negligence claim pervaded the design at tender stage for this large infrastructure project. And we picked off where we thought the most obvious example of professional design negligence was. We packaged that up with geotechnical expert evidence and some structural engineering expert evidence, and we slung it into adjudication again. We had a 6-month adjudication process with a QC or a KC these days, still getting used to that, as our adjudicator. 2 firms of large law firms acting for both parties. It was a 6-month process. The responding party, we knew, and they did, would throw in a lot of legal and contractual arguments as their sort of first line of defence. There were limitation issues, there were issues as to which contract the dispute should have been referred under, etc. We knew all of this was coming, so we had prepared for it in advance. And we got a good decision from the adjudicator at the end of the day. And we got a good decision because we allowed the parties enough time to feel that the issues had been ventilated and aired before the adjudicator in the process. What that led to, ultimately, was us then starting a second adjudication on the next example of professional design negligence. We then agreed to stay the adjudication to allow a mediation, and ultimately the case settled. And that all probably happened within a sort of 8 to 9 month process, with the client getting the money for the whole professional negligence claim in their bank account within 9 months of the starting the process. That's probably twice as quick as you would expect from the courts or arbitration. Technical adjudications, smash and grab, in other words, they are an excellent tool to use to try and gain commercial leverage. You know, they're not very nice because someone's made an error and they've not given a payment notice or a pay less notice when they should have done. But you can sling it into an adjudication, and you can often get a decision, again, within 28 days on a smash and grab adjudication, and that can precipitate a commercial settlement on the final account, or it often happens. You often see it, in my experience, at the end of the project when the QS team have taken their eye slightly off the ball with the payment application processes. What I've seen more recently on that is actually the threat of a smash and grab adjudication has precipitated a sensible settlement. So I had one last week where my contractor client phoned me up and they explained that, yes, they'd not issued the payment notice when they should have done. In fact, it was on 2 projects with the same contractor, so double trouble. And actually the other side, who had the upper hand, made a proposal that my client, who'd not given the payment notice, would simply pay 75% of the applied for amounts. And we looked at the account and we took a view and we accepted the proposal. And it avoided the adjudication, but everybody knew that if we hadn't have accepted that proposal, that we would have ended up in a dispute. My client would have spent several tens of thousands of pounds on legal fees, potentially adjudicators' fees, £10,000. It's just throwing good money after bad. So try and get a pragmatic solution. There is a view that adjudication should be used as a forum to test your evidence. I don't think I really agree with that view. I don't think you should ever use a formal dispute resolution process just to test evidence. I think if you're going to engage in a formal dispute process, then you should go into it with both feet, and you should be going into that process with a view to winning that process, or to putting yourself or your client into the best position of getting a settlement out of the process as a result. So I don't really think it's a process in which you should use it to test the strength of your evidence, just so that you know whether or not you'll win an arbitration down the road. Only adjudicate if you're in control of the process. Don't go off half-cocked. Or a story a client told me yesterday, they started an adjudication 5 weeks before Christmas and then were aghast when they had to spend the period between Christmas and New Year writing submissions to the adjudicator. And I sort of explained to the client, well, what did you expect? You know, plan what you're doing, make sure your evidence is prepared. On the other hand, if you do adjudicate, you can't take advantage of sealed offers or Part 36 offers, which you can in arbitration and the court process, litigation. I quite like sealed offers and Part 36 offers as a matter of, again, trying to obtain commercial leverage and to try and, again, achieve a settlement without expending hundreds of thousands of pounds on legal costs. How I have used that, though, in conjunction with adjudication, is to have a quick adjudication on a low-hanging fruit item, get a successful decision, and almost immediately whack in a Part 36 offer if it's going to be ultimately in the courts, or sealed offer in advance of an arbitration. And the psychology of that can often, again, lead to a settlement discussion between the parties. Even if you adjudicate first, if it all goes wrong and you have an adjudicator who's had one or two many glasses of wine or one or two many late nights watching Question Time and not written a well-reasoned decision, which we do still see from time to time, then all is not lost. So if you've adjudicated first and you've got one of those bad decisions that everybody talks about, you can still go to the courts or arbitration. And again, the threat of that with the other side, where the other side may be represented by decent lawyers who know that it's a bad decision, the threat of that referral of the same issue to the court process can still precipitate a settlement. Finally, but not least, I act for a lot of continental European contractors. They are extremely suspicious of adjudication. So, we talk about adjudication domestically in the UK. Parties know what the process is about, and they know and understand that a lot of decisions are just effectively accepted and it doesn't go any further. On the continent, on the contrary, most of my European contractor clients come to me when I say adjudication, and they say, well, what's the point? Because it will just be appealed. I'll get a bad decision. The decision will be rushed because the adjudicator will be too busy. It will cost me £500,000. Why should I do that? And then I explain to them the 7 points I've just explained a moment ago, and they often agree to adjudicate. Thank you.